Yes,
Their pleasure, lordships.
it looks like you're going to mention adjourn.
Item 11,
Yes.
it's the second hearing item, lordship.
Okay.
Again, the concern from a learned friend
Okay.
for a respondent.
Mm.
2 weeks time, you can leave allowed, lordship.
Who is the other side? The learned senior counsel, Mr. C. Jamir, who was free for 2 weeks,
Lord,
2 weeks time, which is not objected to by the learned government advocate and the learned counsel for any private response. Private response. Accordingly, list the matter up to 3 weeks.
May I please, my lady and my lord,
Yes.
I'd like to mention item number 5 on behalf of MS Nere for state. Can you allow her 1 week time to file objection to the IA? I've taken the consent of the other parties also.
No objection.
No objection.
Third learned government advocate, Mr. K. Angami, who was paid for how much time? 1 week.
1 week.
1 week's time to file the objection in IA Criminal 4 of 2024, which the prayer is not objected to by the learned counsel for the appellant, at least after 1 week. Yes.
Lordships, I'd like to submit a mention memo for listing of the habeas corpus matter, which is due for listing today actually. On 24th of September, this court had allowed me to file an amended writ petition. And thereafter, this matter was directed to be listed immediately. And I filed it yesterday. And since it's a petition challenging the illegal detention, there's some urgency in this case, Your Lordship, if this matter can be taken up after the listed matters.
Keep the list.
May I please, Lordship? Respecting to mention hearing item number 15, Your Lordship. I'm making a mention on behalf of Lima Wapang, leading counsel for the appellant, who has some personal difficulty to Your Lordship. I'm taking the counsel from the opposite party, Your Lordship. So this matter can come after 2 weeks, Lordship.
2 weeks.
Lordship.
Learned counsel, Mr. Sanisach, who has made a mention on behalf of Mr. Lima Wapang, learned counsel for the appellant, and prays for 3 weeks' time. As Mr. Lima Wapang has some difficulties today. Learned PP Nagaland has no objections, list after 3 weeks. Yes.
Much pleasure.
May it please your lordships. Lordships, I beg to mention item 14, hearing item 14. Lordship, may be gracious if this matter may come up after 3 weeks.
You are the appellant.
Yes, lordship.
Third learned counsel for the appellant, Mr. Sanisach, who prays for 3 weeks' time. So, accordingly, list the matter for hearing of the 3 weeks. Yes.
Much.
Your Worships, I'd like to mention item number 12 on behalf of the council for the appellant. Worships, the council has some personal difficulties today, so the matter will come up after 2 weeks.
Third learned counsel, Mr. Sanisach, who makes a mention on behalf of the council, is Esther for the appellants who has some difficulties today. List the matter after 2 weeks. 2 weeks or 3 weeks?
2 weeks.
2 weeks.
Much more.
For orders, item number 1.
Please, your lordships.
Mm.
Lordship, this is an appeal against the conviction under POCSO Act. And the present IA is for the condemnation of 235 days. Yes.
Notice, what about the notice on the informant?
I'm told the notice is complete, but
Notice is complete because it was to be routed through the BP's office.
I'm told that notice has been served.
Actually, I'm not here, appearing on behalf of my colleague S. Naren.
Hmm.
But this
The,
is,
the PP has to ascertain. This is a POXO case, isn't it? Yes.
It has been complete and we have served a copy to Learning Council, my friend, Mr. Sinti Younger. He has accepted the copy, but I don't know why he's not here today. And this, for condonation or delay, this matter has been listed
Yes,
several
yes,
times.
I understand, but since it's a POXO matter, it
Yes,
needs to be
notice.
served notice. That is the problem, yes.
in that case, I pray.
Next week,
Yes.
you ascertain the notice, okay?
Yes.
And if necessary, we'll have to appoint a legal aid or make a amicus for the informant, yes.
There's already accepted notice, but I don't know whether he's filed his power also to appear, but
Anyway, you ascertain everything.
Yes.
Learned counsel for the appellant, Mr. Joshua Sheki is present, appellant slash applicant. And learned PP, Mr. Piangami is present. So the notice on the informant is stated to be served. However, in order to ascertain the same, the PP is given a week's time. So at least after 1 week, that is next week will be, when is the 15th, yes, this on 15th.
Bless your lordship.
For orders, item number 2.
Madam, I appear for the appellant's matter. There is a delay of 294 days, which we are seeking confirmation of. And today, just now, I think served a copy of the written objection filed by the principal, the primary respondent number 1. Union of India is not required in this case, madam, because they don't have much to do. And the, my lord, my lord may desire to come on record. It will be fixed for hearing on the question of delay.
Can we fix it next week?
My lord, I will be on station, my lord, because it will be fixed on 5th of November, if possible, my lord. It is a Wednesday.
Fifth is a holiday here.
5th,
Holiday.
I'll be filing my written objection.
5th
during
is
the
a
course of
holiday.
the-
5th November is a holiday.
Because of the.
29th of October.
29th.
Learned counsel for the appellant. Your name? Such as just present. Learned advocate, Mr. Learned counsel, Mr. Such present.
Lordship, I'll be filing my written objection during the course of the day.
You will be filing or you have filed?
I have not filed, I have served him a copy, but I'll
Just got the call.
Learned counsel for the respondent number 1. So it is submitted that the objections on behalf of respondent number 1 will be filed during the course of the day. So accordingly, please the matter for hearing on the IA on 29th October 2020.
For orders, item number 3.
Mr. Lordships, I have received their affidavit in opposition to my IA just yesterday. So if this matter can be listed on 29th of November.
What is the IA for?
Condonation.
Condonation.
Yes, for condonation.
Learned for the appellant, Ms. such and such is present. So it is submitted that the affidavit in opposition on behalf of respondent of this, in behalf of the sole respondent has been received by the applicant appellant, and it is prayed that the matter may be listed for hearing on 29th October. So accordingly, list the IA for hearing on 29th October.
For orders, item number 4.
Lordship, similar matter here.
Okay, that's right. Analogous, is it?
Yes.
Okay, same one.
Much appreciated.
Obliged.
For orders, item number 6.
Today also none appears. This is transferred from principal seat.
Yes,
isn't it?
yes, yes.
What should we do? Should we send petitioner of the send notice?
Yes.
Today also, when the matter is called, that none appears for the petitioner. So list again on 29th October.
For orders, item number 7.
Your Honor, my name is Mudassir as a public prosecutor for NIA. Your Honor, kindly, return of notice awaited, Your Honor, so kindly fix, 29th of October.
You have taken steps.
Yes, Your Honor.
The address, it just says resident of such and such village. Will it reach? How did you take steps? Registered post?
Yes, but it has not been, return has not been, yet, no.
I have my
Return
doubts.
is awaited, Your Honor.
Anyway, office note dated 6/10/2025 indicates that return service reports are still awaited in respect of respondents number 1, 2, and 3. Stop. Accordingly, list on 29/10, awaiting service report on the respondents.
For orders, item number 8.
Same,
Same, Your Honor.
same.
Right.
For orders, item number 9.
Lordships, this IA is for continuation of delays in briefing the connected appeal. Jail appeal. The delay course is 1075 days.
Notice on complainant.
This is coming up for
Coming
the
for the
first
first time.
Yes,
Okay, okay.
At this stage, if the notice may be issued.
The instant IA is an application under Section 5 of the Indian Limitation Act, praying for condonation of 1075 days in filing the criminal appeal against the judgment and order of conviction and sentence dated 15/9/2022, passed by the Special Judge POCSO Act, PEG, Nagaland, in Sessions Special Case number 2 of 2022 in connection with GR number 2/2022, Women PS PEG case number 1 of 2022. Issue notice to the respondents, 1 and 2, the learned public prosecutor, Mr. K. Angami, has accepted notice on behalf of respondent number 1. Once no formal notice is called for, the notice on respondent number 2/complainant shall be served through the office of the public prosecutor and by routing through the registry. The applicant shall serve the copies for the notice through the registry of this court to be served on the PP, who shall take steps for service on the respondent number 2 through the jurisdictional police station. So, notice is made returnable within 4 weeks.
For hearing, item number 10.
One of the
as petitioner. Is seeking curricular skill upgrade from the date of her initial appointment. My lord, I will be allowed to read your lordship to page 51 of the appeal memo. How the petitioner was appointed. In the sixth of
I think this is the second or third round of litigation, isn't it? You had earlier come before this court.
My lord,
You had come before this court earlier. Yes.
so what I'm trying to say is that to begin from the very beginning
Mm.
of the Srimati Sardinsat is temporarily appointed as sweeper in the office of the Sardinsat government praise branch Mogokcho uncontentiously paid basis at the rate of 375 per month. Fixed. That is the issue. With effect from the date of her training into the appointment is made against the post Sergeant White, order number Sergeant Sarge, dated 9/6/88. So the appointment itself is speak clearly that it is against the sanction post. What is 375? Rupees 375. This is the ROP page 174 of my appeal memo. This is the basic 174 Finance Department ROP rules 1954. Page 175, common categories, my lord. Beyond the other categories drawing identical scale, that is beyond the silver construct, portrait. 375.
No, but this is a scale of pay.
My lord,
This
that
is
is one
scale.
thing.
Yes. Yours is fixed
You,
pay.
my appointment is and at the rate of rupees 375. That is what I am trying to place before your lordship. 375 is the minimum pass without adding the increment other benefits. That is what I am trying to place it before your lord. And I feel like represented in 2000, page 53. $16.54 in 2000. That is the regulation.
But here you are saying 750 rupees per month.
That is the basic fee of the foreign staff.
Oh, you
In
were
1984's ROP rules.
you were started off on 375 rupees per month fixed pay.
My lord, that is what I
Then at page 53, you are saying that I was appointed with a fixed pay of 750.
My lord, the order is 375. Very clear.
Exactly.
Likely there may be,
Some enhancement.
yes, likely. Then what is that 29 February? Page 54. This is 29 February 2000. Type copy is at page 55. Srimati Sergeant Sarge is temporarily appointed. That is what they are saying. In the Directorate of Printing and Stationery, Nakalang, Kohima, you scale up rupees Sergeant Sarge. And a maximum of rupees Sarge in all other allowances as are admissible under the rules from time to time in the state of Nagaland when they pick from 1 click 2000. The appointment is purely temporary only. If any director service was terminated without any information and posted to multiple branch place, that is the same place of posting. So this delayed before
29 February 2000, you got appointed again on fixed scale pay.
Malo. Then next is the same day, Malo. Page 56.
This page 55, the last line, the appointment is made against no vacancy. What does it mean?
Page 55.
Madam, that I cannot explain. Because the petitioner is continuing
you're-
from the day one, it mogok
Your, if your case is based on the premise that it was against a sanctioned post
Malo,
and your appointment was only irregular,
Malo,
then this appointment against a no vacancy, will it not be a hurdle?
Malo. I understand your views. The first appointment is against the sanction post.
It's against no vacancy.
My lord,
Where is the sanction part?
take it. This is the order of the government, which I have no say. Then by next order, that is same day, my lord. Scale up pay, earlier it is 600. By this order, it is 800. Scale up back. The difference is only that scale up pay from 600. That is 29 February 2000. In page 57 is same day, 2 key. One is 2000, that is 600. 2 key is 800. As your lordship has pointed out in this, the appointment is made against no one.
And there's another sentence added to it. It is for a period of 6 months.
My lord,
On page 57, now it becomes 6 months.
but this order was not given effect to. The petitioner was not made that neither 600 or 800. To submit another representation, page 58.
She was not allowed to join
No,
pursuant to
she
this.
was working from the day one. It moved to branch priest,
Hmm.
then low sweeper in that establishment. To the petitioner represented for regularization of service. On 10 February of 2001, which was not attended to. Rather, it was only the extension was given. So the petitioner appellant approves this vote. Page 60. The PVC 215 up to 2018. Earlier, the petitioner approved by filing WBC 141 of 2015. Then
First petition was
141 of year 2018.
where is that?
Page 60 on the second paragraph.
Okay, okay. 140. Okay, that was disposed with a direction to file a fresh representation.
My lord,
which was rejected.
My lord, since I was representing the appellant, it was on the day of the motion. Since the petitioner have not made the representation, apart from 2001, I was directed to file a representation. But actually, the petitioner has come before they spoke for the second time. The first petition side and side was disposed of dated 2018. I directed the petitioner to file a fresh representation before the director. Please fund number 5 within a specified directing for the respondent number 5(2). Dispose of the same by way of a special order within a period of 2 months thereafter. The petitioner filed her representation as directed on 10/8/2018, but the same was rejected by communication dated 28/9/2018. Being agreed, the petitioners filed the instructed petition challenging the same rejection of her representation for her regularization in service. Prefects of the case may be noticed at the outset. The petitioner was appointed temporarily as server in the office of Assistant Director, Technical Government Praise Motu and contingency basis at the rate of rupees 375 per month. By order issued under the memo number such and such, dated 26/10/1988 by the Director of Printing Stationery, Government of Nagaland. Respondent 5, her appointment was met against the post sanctioned by number such and such, dated 9/06/1988. Thereafter, the petitioner will continue to aside for nearly 12 years in having not been considered for regularization. She submitted the representation to the respondent number 5, seeking her regularization in service on 16/2/2000. The respondent number 5 by order 29/2/2000. However, issued an order appointing the petitioner temporarily as sweeper under the directive in the scale of rupees such and such per month, with effect from 1/3/2000. The respondent number 5 being issued another order on the same day appointed the petitioner temporarily as sweeper under the directorate in the same scale of pay as was indicated earlier. The only difference was that her appointment was for a period of 6 months. Thereafter, the services of the petitioner having not been regularized, despite her representation dated 16/2/2000, the petitioner filed another representation on 10/2/2001 before the respondent number 5. The services of the petitioner in the meantime was extended from the time to time by order dated 34/2001 and 77/2003 amongst other. Showing that she was appointed on contingency basis under fixed pay, her regularization having not been considered, the petitioner filed the first petition as already stated here and above. Mr. Sanisad for the petitioner submitted to the petitioner was appointed on contingency basis by the order dated 26/10/2018. But the fact remains that she was appointed against a sanction post as indicated in her appointment number. The petitioner will continue in service since her initial appointment was subsequently appointed again on temporary basis. Against the same post, but in a pay scale up. Pay scale by the 2 orders, both dated 29/2/2000. He submits that although the 2 orders speak about the appointment of the petitioner in a scale of pay, but the petitioner was never given this, given a base scale, but only a fixed pay, which was revised from time to back. Mr. However, submit that non-payment of base scale cannot come in the way of.
You come to the observation of the court.
My lord.
Para 13.
Yes. Upon due consideration of the case, it is entire, in its entirety, I am of the view that the case of the petitioner for regularization should be considered by the respondent on a special case, keeping in mind that the particular effects and consequences of the case, non-availability of vacancy in the posts of labor, but we cannot be that from that to consider her regularization. It will be incumbent upon the respondent to create the supernumerary rules to accommodate the petitioner for her regularization which will require. The post created will be personal post in Chelsea, which is once the regular vacancy occurs in the market, such regular vacancy.
So after that, the supernumerary post was created.
Malo. The one fact remains that this it is clearly reflected in the order itself that it was against the sanction post. The first appointment is sanction post. This honorable court observation is very clear. In the first part, it is clearly given that appointment against sanction post. So
No, but the respondents, they said that the relevant file could not be traced out. And there being no vacant post, her service cannot be regularized. That was the stand.
that's what they are saying, but the fact remains that the order I have to go by the order. It is not my order, that is your order. So traceability of the file or not, that is not the doing of the petitioner. It cannot be imputed against the person petitioner. They are not denying that about the appointment against the sanction box. In working on full-time basis all along. Through this page 70, the government has given that for regularization. Supernumerary or whatever it is, it has to be from the day of her appointment. Two, this government approval may be seen. I'm directed to refer to you later in my silent sites. On the subject cited above, inclusive with the copy of the meeting, minus of the cabinet held on silent sites, conveying its approval for creation of supernumerary posts for regularization of the service of ceremony silent sites. Sweeper. So the question is regularization. It's not a question of continuity. It's not a question of dismissal. The whole question was, if this honorable court direction was to regularize the appellant service, to rightly the government has convened for regularization of the appellant. However, what happened is this, page 71, type copy 72. This is date is negotiated in June 2022. Consequent upon the approval of government for creation of one supernumerary post for regularization by second sides. Cabinet Secretary Sale later number side inside, in home department later number side inside. Srimati side inside. Inside. As appointed. Mariana appointed as contingency sweeper is hereby regularized. It is a which is it, that is the holy human. Why 14/6/2022? This is not as per your own orders, neither as per the approval of the government. at Moulton Branch Place. That is the place upper wood from that new one. Under the Directorate of Printing Stationery Department, the bill level up to besides. Plus, all other allowances are admissible under the rules enforced from time to time with effect from 14/16/22. Her service shall be regulated in the old pension scheme with the period rendered on fixed date basis counting towards qualified service for the purpose of pension benefit as per the details given below. To date of appointment, clear. Only the date of regularization should be from the date of appointment. That is the whole. Two, her post shall be automatically exercised. Three, most interesting, the seniority shall be counted from the date of regularization, the loan post. Two, you are generous in giving all that thing which is have no relevance when it is a loan post. But about the regularization, working all along from the day one, in a sergeant post, that part has been left out. Or that,
14/6/22 must be the date of cabinet approval,
my lord,
perhaps. Cabinet is 13/6.
yes. Cabinet. So what I'm trying to see is that when the question is decided for regularization, it's not a appointment, not a reinstatement. Once this decided that to regularize, regularization has to be from the day one. With the order is clear that it is a sanction post. Not my creation, that is their own order. Okay. We have to go with the order what it says. And it is not my order, it is the order of the government. For this particular period of time, the petitioner approached this court by filing the PVC 206, which starts from page 36. Prayer 49, page 49. To regularize the services of the petitioner as waived from his spending 1988 with the recovery skill update. That was the issue. Waiver is the single tranche by judgment order dated starts from 189. Judgment dated 28/8/2024. The prayer was rejected. The main reason for rejection is that I didn't make out the case that I am discharging like other sweeper in my writ petition. My main trust is based 40. Page 2. Page 40. Paragraph. That the petitioner was temporarily appointed as sweeper in the office of signing size. Uncontentionally fixed the above signing size. Possibly by the director. Grant the date of appointment on full-time basis against the something post. The petitioner is charging the duty of sweeper in this establishment in office of the assistant director moved to branch, please. It is stated herein that 6/26/10/1988, if the petitioner is the lone in sole in lone sweeper of Mobutu branch, praise for his held in Manok. Very good. 165. In here, the government implies page 166. Paragraph. This is clear. The possession starts from 165. That the statements made in paragraph 2 of the repetition is admitted to the extent borne out by the courts. The code is something code, but not otherwise. It is respectfully submitted that the appointment order of the petitioner clearly states that the petitioner is temporarily appointed on contingency basis in predetermined action anytime without any notice. So, about the petitioner being appointed against the sunken post, the lone sweeper, in working from the day one, which is not denied very clearly by the authority. Page 21. Page 21. That is the release order of the appellant.
Each,
The release order of the appellant.
each.
Page 21 of the appeal.
Retirement.
Malo, on completion of 35 years of service. You are taking everything to call for it except the skill of them. I have no objection to this also, but see, from the day one, after appointment against certain posts, counted it, see, when retired. So when everything is being counted, when other skill of it, it's not that the petitioner appellant is asking something out of the way. The deal of the appellant is able.
No, but for that, the Nagaland Retirement from Public Employment Act.
I
It says
understand.
that the period, yeah, spent on
Because-
contract ad hoc will also be counted. Yes.
So that is what I see. When somebody is appointed against something, there is a order for recovery. It's not a question of new appointment. Reinstatement. What an artificial thing. This of our human.
Now you are getting your regular scale of pay. You are getting your,
Yes.
no, after your regularization, you got the regular pay,
Malo.
scale pay.
Yes.
What you want is the fixation from the date of your appointment
Malo.
on regular scale. And are you paying for arrears
Malo.
for that period?
Malo. This another cook in my case, I para my submission and the ruling starts from para 5. Citizen bench in Surinder Singh in another versus chief engineer. Engineer in chiefs. That is. My. This is MLA, which is AMD. That is appeal memo bench. AMD. 75. The ruling which I includes in the proceeding itself. It's 75. I've instructed the central government, the state government, likewise, that is page 75. Halfway. After this, Nakara in others versus Minanapungi. The central government, the state governments, likewise, all public sector undertakings are expected to function like model and enlightened employer, and arguments such as those which were advanced before us that the principle of equal pay or equal work is an abstract doctrine which cannot be enforced in the court of law. Should ill come from the mouths of the state in the state undertakings, we along with the basis in very the respondents as in Niruduva Indra case to pay to the petitioners all other daily rate employees, not only the petitioners, and all other daily rated employees to pay the same salary in allowances as are paid to the regular and permanent employees, with effect from the day that we were respectively employed. Manoj. In this case, even the cost was improved. Then page para 6. Page 87. This is UP Land Development. 2010, 7 ACC. 21. In the result, the appeal is partly allowed. The impugned order is set aside. However, the appellants are directed to pay to the respondents minimum of the base skill prescribed for the post of assistant engineer as devised from time to time from the date of their appointment. And 7 days, page 162 and 163. This is exactly same case.
You are getting your pension on the basis of
Yes,
return.
yes.
Everything is.
Yes.
Your only grievance is the fixation of your pay at the regular scale
From
from
the
the date
date
on which you were appointed,
Month. In
arrears thereof. And you are asking also for arrears
yes,
for that period.
yes.
And now your pay, now your pension has been taking your basic pay to the
That
board.
I've not
No.
asked from the
If your regularization is done from the day when you are appointed,
month.
definitely the scale at which you would now have reached, the pay, the basic pay that would have now come up, all that will alter. Your pension would also have to go up.
Well, it has to. Unless they work out from the day one, the skill up there.
So this judgment this judgment which is now being impugned at page 203, it has divided your prayers into two parts, the relief. Your retrospective regularization has been rejected.
No, retrospective regularization they have already given.
Just.
Yes. So
At
what is
page
really-
203, the
Yes.
Honorable Judge holds that retrospective regularization has to be rejected.
That is
But you already have your retrospective regularization is what we understood.
given.
So the only prayer that now remains is the second part of the order, which has denied you the regular scale of pay from the date of your appointment. That is the only thing that is to be decided. in this.
So, the case. Judges saying the principle is held that equal pay for equal work, expounded through various decisions of Supreme Court constituted law, constitutes law declared by Supreme Court, which is binding on all courts. That is in the heading. Paragraph 57. There is no room for any doubt that principle of equal pay for equal work has emerged from an interpretation of the different provisions of the Constitution. The principle has been expounded through a large number of judgments rendered by this court. It constitutes law declared by this court.
Now, when you are saying you did not get equal pay for equal work, what was your pay and what was the pay of your counterpart
That is what
on regularization?
before your lordship about the 1984.
Not on that. You are now saying that you did not get equal pay for equal work. Did you get equal pay as per your counterparts after your regularization? Was your pay kept at
Yes.
equivalence?
Yes. From the date of effective date of the declaration.
Yes. No, you were given the scale.
Yes.
You were given the scale, but were you given the equal pay is what I'm asking you.
Yes.
Because if you say you were given equal pay, then they must have fixed your pay, taking into account the past service.
No.
Otherwise, it will not come to that particular basic pay.
Regularization, I've been given the
Minimum.
scale of pay.
Minimum,
Yes.
minimum at the scale.
Yes.
Were you given minimum at this scale or was it calculated?
With all the benefits from the date of regularization. With all the attendant benefits. Unlike in the first appointment. Then page 87. Next 187. Then page. Yeah, no. 181, madam. Page 181. Which is this another court order. Mirror, it's a short order, judgment. This application has been filed on behalf of the master room worker who was appointed as far back as an 2051 as a plantation Mali fire watcher. Annexure 1 to the data application. In 84, the petitioner was transferred as skilled laborer to the office of the range officer. Third ward. But till today, the service of the petitioner has not been regularized. regular Annexure 3, 4, and 5 will feel that the petitioner was holding the same vacancy. Post of plantation Mali started by government later dated 1980. It is an independent position that there is an existing vacant post. And that also is subject by the government. In that view of the matter, there can be no earthly reason as to why the service of the petitioner should not be regularized. On 2193, the Divisional Forest Officer, Social Forestry Department, wrote to the principal conservator of follows that the petitioner even may be appointed as forest guard in the division. Considering all these aspects of the matter in after hearing research insights, I direct that the respondent number 2, 3, and 4 shall do the needful to regularize the service of the petitioner, either as forest guard for plantation Mali and or any other suitable vacancy within a period of 3 months from the date of receipt of the order. The regularization of the service of the petitioner shall be made from 2/12/81, the date on which the petitioner was initially appointed, and proceeding to make the regularization from such and such as the petitioner is working in that post is that considering the fact that the petitioner belongs to both strata of the society in subsequent point of time, there will not be difficulty to receive the pension at the end of her service period.
Yes.
Then what? Page 184, my lord. This was the appeal referred by the state. It was decided by Michael Minister of Justice. Para 11, my lord. In the case of Farisad, reported that it is been held that the validity of the order, that is the appointment order, must be judged by the difference to maintain and cannot be supplemented by very reasonably otherwise. In my case, it is admitted. The order dated 28/2/2006 has to be read on the basis of the affidavit contents mentioned in the said order. That is my initial appointment. The order having categorically stated that the respondent was appointed on compassionate ground in view of the death of her sister inside, who was serving as stylist in the the appointment of the respondent has to be deemed to be on compassionate basis. There can be no other interpretation. Accordingly, the appointment being made to a regular sanction post. The step appellants were found to be the respondent in a regular scale of pay as applicable to the post in which the respondent has been appointed. The combined reading of the judgment orders I just said in order makes it abundantly clear that the respondent was appointed under time and harness scale. A case, a regular sanction post. Of her deceased sister, the appellants are bound to pay Malo. That is the issue. To pay the respondent the regular scale of pay. And it's to the same post. The appellants are thus directed to regularize the service of the respondent against the post of titles which was occupied by late sister, Sadiasas, who died in harness. Thereafter, the state appellant shall pay the regular scale of pay to the respondent. The respondent data.
Thereafter, the state appellant shall pay the regular scale of pay to the respondent. Thereafter.
Malo, that is why she was given the vote. regular scale of pay. In this case also, it was only about the scale of pay from the date of approval.
No, here they say that you will regularize the service of the respondent and thereafter pay the regular scale of
Yes.
pay. Where is the retrospectivity?
In the writ petition,
Which writ petition?
this is in the appeal. This is my case. No killing one. So whatever
That
it
is-
was, he had not given the scale of pay.
They did not give a scale of pay at all, and this court say that she's entitled to give the scale of, she's entitled to a scale of pay, regularize her service, and thereafter give her the, so
Yes.
that what thereafter would
Whatever
be
is,
after the regularization is what we understand. What do you say?
since this is my case.
You got
My
your
case
regular scale
was-
after your regularization.
Oh, this scale of pay from the day of her appointment.
But that is not
Then-
reflected in this order.
This, the government, the single pay says that should be with the scale of pay. Since I was appointed,
Granted.
then the government take it to the division bench. It was rejected. And it would only the petitioner in this particular case. He was given
This Nokile want.
no chili one. One, seven. One. No.
Do you have the judgment of the learned single judge? Because at page 183, if you see, learned single judge has said that regularization will only be considered when the vacancy arises. Presently,
One of the order was to pay the scale up.
from when? The issue is from when?
One of the whole issue was the writ petition itself was for the scale up
From when?
from the date of her.
Where is that?
One of
Where is that reflection? Page 183, it simply says the learned single judge directed the respondent should be considered for paraphrase. Yes.
Full judgment.
Simply, not the whole judgment, read out the relevant part.
182. The state of Nagaland has filed this appeal against the order dated 13/6/2020, passed by the learned single judge in Sarit, where the appellants have been directed to pay the regular skill of pay to the respondent petitioner, even though she was appointed on a fixed pay basis. True, that is clear.
In this judgment, we do not find
If you will be considered the first paragraph.
yes.
The state of Nagaland has filed this appeal against the order dated 13/6/2012, passed by the learned single judge with the application number 1/259 wherever the appellants have been directed to pay the regular scale of pay to the respondent petitioner, even though she was appointed on the fixed pay basis.
Now you have been granted the regular scale of pay on your regularization. The only issue that now is before this court that you are trying to agitate is that the regular scale of pay should be fixed from the date of your appointment and that you should be paid all the areas that would have come on such fixation. Now, in this judgment, just show us one sentence which says that the court had granted the regular scale of pay to be granted from the date of your appointment. That particular phrase, regular scale of pay from the date of appointment, is what we find missing in this judgment. If you can help us by reading out that particular sentence which says that this court has not denied you, the respondents have not denied you the regular scale of pay. They have granted you the regular scale of pay. The issue is from when.
from the date.
Since you are saying that it should be from the date of appointment, show us one sentence in this judgment that where it says the regular scale of pay has to come from the date of appointment. Just that one sentence, if you show us, our work becomes easy.
The order date 28/2/2006 has to be made on the basis of the candidates.
Yes.
That is, it is the something.
Either I'm not
No,
being able
but-
to convey myself.
My brother has pointed out, see, your para 11 is the operative portion. It says appellants are directed to regularize the service of the respondent against the post of typist, which was earlier occupied by the respondent's late sister, who died in harness. Thereafter, the state appellant shall pay the regular scale of pay. So which means they will regularize you and thereafter pay the regular pay scale. That's what we understand.
The fact is this. It is on the basis of this post of the single payment, which is affirmed. This particular person was better skill up me from the date of her appointment.
Where do we find it? Your statement is not working, sir. Where do we find it? We need some record for that. Either in the judgment or a piece of document. Something I'll have to have before me. It cannot be done on simply on your statement. And that is what the learned single judge has said, that you have not put forth any document in your writ petition showing that people who were regularized, given regular scale of pay from the day one, or that they had a different pay scale than yours, or that you are being given less. You have put in nothing. To help us adjudicate your claim, we must have those particular sentences or phrases, or we must have that particular document before us with which we can give you equality. If that document is not before us, or based on what do we say? Do we say Mr. So-and-so has asserted that others are getting regular scale of pay from the date of appointment on their regularization, and we accept his statement? Cannot be so. We have to refer to some document to say this is where we get it. One other regularization order saying that yes, it is from the date of initial appointment. Unless you can show that to us. Because all your other prayers have been answered in your favor. You got regularization, you got your pension, you got your regular scale of pay, everything. Only bone of contention, from what date, and am I entitled to salary or to arrear or not? That is the only contention. Now, unless you put before us some example.
Without even, let's not nuclear one. Without that also, the Supreme Court is clear that it has to be from the date of.
Show us. Which judgment? Show us that it has to be from the date one. That when you are regularized, you will be given from day one. Show us that sentence.
In my case of appeal, perhaps.
Which is the case?
When you say in another. Page 75.
Yes.
It starts from 73. Supreme Court, the reason notes. The render saying in another verse.
Equal pay for equal work, that principle has undergone a lot of changes from 1986.
Page 75. The central government The central government, the state governments, likewise, all public sector entities are expected to function like model and enlightened employees. In arguments such as those which were advanced before us that the principle of equal pay for equal work is an abstract doctrine, which cannot be enforced in the court of law, should ill come from the mouths of the state in a state undertaking. We allow for the repetitions if the respondent as in Niruva Kendra to fill the petitioner and all other daily employees, not only the appellant, to pay the same salary and allowances as are paid to the regular and permanent employees with effect from the day we were respectively to.
Yes, anything else?
In one, just take the worst view of the matter. In by division by the Supreme Court in Umma TV. In 2006, it is been clearly given that the state in its instrumentality should regularize those persons who are irregularly appointed against sanctionable, which is exactly is the case of the petition. To that, it just should have taken care of the petitioner case. What if we trip of Umma? Much obliged.
Yes, government.
Bless your lordship. This is the fourth round of litigation. If we count this appeal, this is the appeal. I'll take your lordships to the first to the appointment order. That is in page 52. Page 51, 52. 52 is the type copy.
the petitioner was appointed as a sweeper on contingency fixed basis. Now, the appointment is made against the sanction, both sanctioned by voters, so and so, 9/6 dated 9/6 to 1988. The appointment can be terminated without anytime without any notice. My only question is how my learned senior friend could relate that since he was appointed, she was appointed on a sanctioned post, she should be regularized from the date of appointment. How can he relate that? Because the appointment itself, forget about the sanction post, forget about the name of, but the category he was appointed was sweeper and a contingency facts bill. At the initial stage of the writ petition, when we tried to trace out this very appointment order, we could not find that because Directorate Office was also shifted and it was a long 1988, I was in class 10. So now, the appointment order itself is produced by the then director. So we want to help the petitioner by tracing out the appointment order as well as the file, both in the government as well as in the Directorate Office. But we could not trace it in spite of our best effort, so that we could do something. Because the petitioner was saying that he was in a sanction post. So we have to find out that and try to do something, but it was not traceable. So the appointment order has been given by the director, and whether this regular selection process was made or not, that is also not there. Whether the concurrence of this government, approval of the government was also taken or not, that is also not there. So that way it was like that. But when this honorable court has ordered, I'll take your lordship to page 69. The order of when we were directed by this court in page 69, I'll just read the operating paragraph. That is on 15/2/2020. I'll read the operating paragraph 15, page 69. The respondent number 5, within a period of 3 weeks from the date of the receipt of the certified copy of this order, shall initiate the process of regularization in terms of the direction herein above, if necessary, by obtaining approval of the administrative department. All the respondents shall cooperate with the process, and the entire exercise be completed within a period of 3 months from the date of receipt of a certified copy of this order. Pending such consideration, the services of the petitioner should not be varied to her disadvantage in any manner. So that was the order. So following this order, your lordship, we have written on June 15, 2022, the next page 70. The directorate has written to the government. The government has written to the director. So cabinet has approved the creation of a subordinate post, because the post in which she was supposed to be a sanctioned post, it was not found. So we have to do something.
That
So-
has been taken care of at page 67, para 12. Kindly come to page 67, para 12.
Page 67, para 12.
You have not made any appeal against this order. Para 12, kindly read.
Page 67. Yes, we admitted that. We admitted that.
Then your not tracing out the file was held to be inconsequential.
No, we admitted the fact that because it was written by the authority of the then.
Whatever be the situation,
Then we have.
at this stage, after this order, after this finding of the court, after the finding of the court that it is an admission on your part that she was appointed in a sanctioned post. Now the issue whether you can trace out a file, you cannot trace out a file, that becomes inconsequential. Later on also it is said so. In this connection, it may be seen that the petitioner was initially engaged by order dated so-and-so. She still continues to be engaged till date. The same can in no way be considered as a part-time employment. You never appealed against this order. You accepted the position.
We have accepted the position, but your lordship will please appreciate the process of the working of the government. Now, we have the best and some files, some reform. We cannot simply go like that. But since it was very old document, 1988, we could not trace it out. Whether the approval of the government was taken or not, whether the file even in the directorate also, we could not trace it out. That was clearly, we have clearly debated before this honorable court.
There are two things. The file does not exist and the file cannot be traced out. Your stand was that the file cannot be traced out, therefore admitting that there is a file which is now not being traced out. Therefore, it was an appointment on a sanctioned post. Your not being able to trace out a file, why should that deny the petitioner all the benefits?
That is why, since we could not trace out the file under which we have to start a process. That is why we have created the supplementary box. That is why we have created the supplementary box. And your lordship, supplementary box, here, 72 you will find. Supplementary box and subsequent regularization. We have given the effective date of regularization as 14/6/2022. 14/6/2022.
So therefore, had the file been traced out, if you could have traced out the file, you would have given it from day one. You're losing a file cannot be to her detriment.
If we could have traced out the file,
should have got everything
in the directorate,
then they
the
would
petition could have been dismissed because whether selection process was there, what not was there.
Those are gone things.
Everything was.
Those are gone things.
Those are now immaterial in view of the
Yeah.
judgment.
And your
of the
failure.
court.
Your lordship will come to the findings of the learned single page. The judgment, which is under challenge, which is under review in this bill. I'll not read the authorities, but I'll just read this thing so that your lordships will be able to appreciate why this appeal has to be dismissed. Page 190. It starts from 190. The impugned judgment order passed by the learned single judge. May I read your lordships? Heard Mr. Judgment in the date of judgment to the 8/8/2024. Heard Mr. I.M. Longja, learned counsel for the petitioner, and Mr. Mo I.M. learned senior government advocate for the state respondent. The limited issue raised in the read petition is for retrospective regularization of the service of the petitioner with regular scale effect. The facts of the case in brief are as under. That by order dated 6/10/1988, issued by the Director of Rendering Stationery Nagaland, Kohima, the petitioner was temporarily appointed as a sweeper in the Office of Assistant Director, Technical Government Branch, Mokchung, on contingent basis, rupees 375 per month, with effect on the date of the joining of the duty. The appointment was made against a sanction post by order so dated 9/6/1988. That the petitioner on 16/2/2020 submitted a representation to the Director, Printing Press, Nagaland, Kohima, for regularization of his service and for scale up the regular sweeper. That by order so 19/2/2020, the petitioner was temporarily appointed as a sweeper in the Directorate of Printing and Stationery, Nagaland, Kohima, and the skill P was given so plus special compensatory remote locality allowances with 5% of the basic pay to the minimum of rupees 125 and a maximum of rupees 1,200 per month, and all other allowances as as are admissible under the rules from time to time in the state of Nagaland with effect from 1/3/2000. The appointment was not made against a vacancy. A similar order in the same date was passed with only difference in the scale of pay, rupees so and so per month. That thereafter the petitioner again made a representation dated 10/2/2021 to the Director Printing and Stationery Nagaland Kohima for regularization of service as well as for scale of pay. That subsequently by order dated 34/2000 issued by the Director Printing and Stationery Nagaland Kohima, the contingency service of the petitioner at a fixed fee rupees 750 per month was extended for a period of 6 months with effect from 1/4/2021. The petitioner filed the WBC 122/15 of 2018 for regularization of her service, which was disposed of by this judgment order dated so and so. Let me read this. The operative portion of the said judgment read as follows. Upon due consideration of the case of its entirety, I am of the view that the case of the petitioner for regularization should be considered by the respondents as a special case, keeping in mind that the peculiar facts of and circumstances of the case. No availability of vacancy in the post of saber presently cannot be ground not to consider for regularization. It will be incumbent upon the respondent to create a supernumerary post to accommodate the petitioner for regularization, if so required. The post so created will be personal post and subject and shall cease to exist once the regular vacancy occurs and the petitioner adjusted against such regular vacancy. The respondent number 5, within a period of 3 weeks from the date of receipt of certified copy of this order, shall initiate the process for regularization in terms of the direction given herein above, if necessary by obtaining the approval of the administrative department. All the respondents shall cooperate with the process, and the entire exercise shall be completed within a period of 3 months from the date of the receipt of certified copy of this order. Pending consideration of the service of the petitioner shall not be varied to her disadvantage in any manner. Pursuant to the order passed by this court, the government of Nagaland Home Department Printing Stationery branch wrote the letter dated 15/6/2022 to the Director Printing and Stationery Kohima, Nagaland Kohima, conveying approval of the cabinet for creation of supernumerary posts for regularization of the service of the petitioner. Consequent thereto, by order dated so and so, dated 28/6/2022, issued by the Director Printing and Stationery Nagaland Kohima, the contingency service of the petitioner as a swiper was regularized with effect 14/6/2022 at Mokchung Branch Press Office under the Directorate of Printing and Stationery Department, and pay level so and so of the pay matrix plus all other allowances as are admissible under the rules enforced from time to time. The order dated 28/6/2022 was also provided that the petitioner's service shall be regulated in the old pension scheme with a period rendered on the fixed basis counting towards qualifying service for the purpose of pension benefits as per the following details. So detail is given. The order further provided the seniority of the petitioner shall be counted from the date of regularization. However, despite order 28/6/2022 issued by the government creating supernumerary posts of swiper and regularizing the contingency service of the petitioner in the said post with effect 14/6/2022, the petitioner has filed the present rate petition seeking for retrospective regularization of service from 26/10/1988 till 13/6/2022 for the payment of regular scale of pay to the said post. Mr. M. Kilongja, the learned counsel for the petitioner in support of his submission, submits that the petitioner was appointed as a server on 26/10/1988 against a clear sanction post and continued in that post without any interruption till she was regularized in service. Therefore, the service of the petitioner shall be retrospectively regularized in that post from the date of initial appointment, that is 26/10/1988. It may be stated that the petitioner was regularized in the post 14 with effect 14/6/2022. Mr. M. Longta, however, submits that the date of regularization, that is for 14/6/2022, reflected in the order dated 28/6/2022 22 is artificial deed and cannot be recalled for regularization of service of the petitioner, and the petitioner's service must be regularized with effect 26/10/1988 with regularized scale of pay. Mr. M. T. Longchar also submits that although the order dated 29/2/2000 issued by the Director of Printing and Stationery, Nagaland, Kohima, the petitioner was granted scale of pay. However, such benefit was never extended to the petitioner for reasons best known to the state respondent. The Learning Council for the petitioner further submits that the petitioner has been serving as a loan sweeper in the office of the Moktong branch office since the date of her initial appointment, that is 26/10/1988, and as such, there is no reason as to why the regular scale up pay should not be paid to the petitioner as paid to regular servers in the department from 26/10/88 to 13/6/2022. That is the date immediate prior to the regularization of the service of the petitioner. In support of the submission, the Learned Counsel for the petitioner has relied upon the following so cases. Mr. Moore entered the Learned Senate Government Advocate under hand referring to the later dated 26/10/1988 submits that the petitioner was only temporarily appointed to the post of server on contingency basis, rupees 375 per month, paid with effect from the date of the petitioner joining the duty. It was also submitted that it was only in compliance with the order dated 13/2/2020 passed by this court in WBC so 2018 that the supernumerary post of server was created by the government and by order dated 28/6/2022 issued by the government of Nagaland, Directorate of Printing and Stationery, Nagaland, Kohima. The contingency service of the petitioner was regularized with effect 14/6/2022 at Moktong Branch Press Office under the Directorate of Printing and Stationery and pay level so of the pay metric plus all other allowances as admissible under the rules enforced from time to time with effect 14/6/2022. Mr. Moore accordingly submits that the regular service of the petitioner as a server in the department has to be counted only from 14/6/2022. That is the effective date of regularization in the service and not from the initial date of appointment, 26/10/1988. Mr. Moore therefore submits that the case of the petitioner for regularization and service from the date of initial appointment and to the the regular scale of pay for the said period is not substantiable in the law. Heard the counsel for the parties by the order dated 26/10/1988, the petitioner was appointed as a contingency sweeper on fixed pay basis in the office of the Assistant Director, Technical Government Press Branch, Moktong, although the order stated that the appointment was made against the suction post. The service of the petitioner was regularized only with effect from 14/6/2022 by issuing the order dated 28/6/2022, consequent to the order dated 3/2/2022 passed by this court. And WBC 215 of 2018, directing the state respondents to consider the regularization of the service of the petitioner, keeping in mind the particular facts and circumstances of the case. It is also seen that subsequently by order 29/2000, passed by the Director of Printing and Stationery, Nagaland, Kohima, the petitioner was temporarily appointed as a sweeper in the pay scale. The Director of Printing and Stationery, Nagaland, Kohima, has thereafter again issued an order dated 30/4/2001, extending the contingency service of the petitioner from rupees 750 per month for a period of 6 months with effect 1/4/2001. There is nothing on the record as regard the fact of the order dated 29/2/2000, nor has the petitioner made any submission on the said order except about statement that she was never granted scale of pay as reflected in order 29/2/2000. From the pleadings exchanged between the parties, the material available on record, and the submission made by the Learned Counsel for the parties, it is abundantly clear that the government, by issuing the order dated 26/10/1988, appointed the petitioner as server in the department on contingency basis on a fixed pay, and the petitioner continued to work in that capacity till she was regularized with effect 14/6/2022 by the order dated 28/6/2022 22. The petitioner therefore cannot claim regularization and service with effect from the date of the initial appointment, that is 26/10/1988, till the date of our regularization and the service, only on the ground that the appointment was made against sanction both. The petitioner was regularized in service of the department only with effect from 14/6/2022, and prior to that, petitioner was not born in the regular service of the department, although appointed on contingency basis with effect from 26/10/1988. Therefore, the case of the petitioner to retrospectively regularize the contingency service of the petitioner is not substantiable, but also not legally tenable. The order dated 28/6/2022 issued by the department regularizing the service of the petitioner with effect from 14/6/2022 has also clearly and correctly spelled that the seniority of the petitioner in service shall be counted with effect from the date of regularization, that is 14/6/2022. The law is well settled that a person cannot claim retrospective regularization or seniority in service even before being born and regular service cadre. The petitioner's claim for retrospective regularization in service commencing from the date of initial appointment is therefore liable to be rejected. So these are the case laws, your lordship. Your lordships may come to page 201, last paragraph 20. 201, paragraph 20, last paragraph. In the case of Dani Belo versus State of Arunachal and others reported in 2011, 2 GLD 688, the Honorable Division Bench of this court has inter alia held that the appointment of the respondent number 4 has been made without holding any selection process. Such appointment was arbitrary and illegal, and the question of retrospective regularization of such an appointee does not arise at all.
No, but in this case, you yourself have admitted that it was against a sanction post.
We admit that because in the appointment letter it is.
And she continued all along. You allowed her to continue.
The only aspect that now we can look into is whether the petitioner appellant had the right to have a regular pay of scale fixed from the date of appointment, and whether she is entitled to any arrear salary. The other part of the contentions that are now being argued is already dealt with by your order of regularization. You have regularized her service.
Correct.
So now there is no gainsaying that she should not have been regularized. She did not have a right of regularization. All those things are now the past. There is an order regularizing her services. So
Correct.
all those arguments go.
Correct.
There is an order of regularization. We will
Correct.
start from there.
Correct.
Once we start from that point, we will have to see whether you are giving her the benefits of regularization from the date of the order that you have passed, or whether regularizing the service would mean that she is entitled to the benefits of the service already rendered by her. If her service was not illegal but was irregular and has been regularized, we would like to know why she is not entitled to a scale of pay for the period of service rendered, when that period is being taken into account for counting her services for the purposes of pension. You are counting that service for the purpose of pension.
Correct.
Therefore, admitting that so therefore she has worked for that period.
Yes.
If she has worked for that period, as have others like her, other sweepers like her have, other cleaners like her have worked, then why is she not entitled to the salary or the scale for that period also? She had rendered equal service. That is not denied.
But we're not denying.
So now if she has rendered equal service with other people, then why should she not be entitled to a scale of pay for that period equal to what others were drawing? Number one. And number two, if she was entitled, why would she not be entitled to get the arrear? That becomes an arrear of pay if she is entitled. So it is only on that point, if you clarify us, if you argue, we are satisfied. The question of whether she is entitled to a regularization or not, retrospective or not, retrospective effect you have already given. You have counted the period for pension. So that regularization has come, retrospective.
Yes, your lordship.
Only thing is, for that service rendered, does she get a scale of pay? And if she gets a scale of pay, should she get an area? That is the only issue. It is only financial issue now.
We are just following the order of this Honorable High Court.
Yes.
Honorable High Court, if possible, create separate number above, because there was no vacancy. For regularization of a certain individual in the department, there has to be a clear vacancy, regular vacancy. It was not there. It was not there. And as I have said before, the very file was not, we could not.
All done, but
so
yet
that way,
once
after considering all the matters, well, we could only create separate number above.
What we want to know is, and what was the reason why you have denied a regular scale of pay
from the data
or area of pay to her when she has admittedly worked according to you?
She has worked. She has worked. There is no doubt about it. We admit that she was working.
Yes.
But when she was working, and a contingency fix, because her appointment is contingency fix.
Then your argument will be hit by what this Surinder Singh case and Nakara case.
Because your lordship can please appreciate the creation of the supernumerary post for the petitioner was a policy decision of the state. That is the cabinet decision. Cabinet has at length discussed the matter and come to a conclusion that this should be the most appropriate. So that was the decision of the cabinet and what produced the order.
Decision of the cabinet cannot be said to be so sacrosanct that it can override the law. Can it be said to be so? Can it override the law? If there is an error, because if you come to page 74, just come to page 74 once. Page 74.
Yes, lordship.
If you come to the third paragraph from the top, the argument lies ill. Did you find it? First paragraph is bench of this court.
Yes.
Then we are therefore.
This argument lies ill in the mouth of the central government for
it is.
For it is not at all.
It is an all too familiar argument that exploiting class in a welfare state committed to socialist pattern of the society cannot be permitted to advance such an argument. It must be remembered that in this country where there is so much unemployment, the choice of the majority of the people is to starve or to take employment on whatever exploitative terms are offered by the employer. The fact that these employees accepted employment with full knowledge that they would be paid only daily wages and that they will not get the same salary and condition of service as other class 4 employees cannot provide an escape to the government to avoid the mandate of equality enshrined in Article 14 of the Constitution. This article declares that there should be equality before law and equal protection of law. And implicit in it is the further principle that there must be equal pay for equal value. It makes no difference whether they are appointed to sanctioned post or not. So long they are performing the same duties, they must receive the same salary and condition of service. One would have thought that the judgment in Nehru Yuva Kendra concluded further argument on the question. However, so-and-so learned counsel reiterated the same argument and also contended that the doctrine of equal pay for equal work was a mere abstract doctrine and it was not capable of being enforced in the court of law. We are not a little surprised that such an argument should be advanced on behalf of the central government 36 years after passing of the Constitution and 11 years the 42nd Amendment proclaiming India as a socialist republic. Then the Supreme Court goes to say that everybody and anybody who has worked there will be entitled to that pay, whether his daily wages, whether his contractual, whether his fixed pay, whether his anything, give him the same salary. This is what you have to overcome.
No, I leave it to the wisdom of your lordships, but
We need assistance.
Yeah.
We need
he's
assistance.
out of service also. The petitioner is out of service
Now.
also. Now,
Now,
maybe
Suspension.
petitioner was released on 31/10/2023, 2 years ago, after 30 years of service.
35 years.
As per the
the
petition.
writ petition was of 2020 or 2022, if I'm not wrong. So it was done while she was in service.
Maybe her pension, everything might have done
Yes.
by now.
But even then, can there be a reason to deny her the benefits of a regular scale of pay along with her equals? Because if you say a constable in the Nagaland police or in the Assam police may not be doing the same work as that of a constable in the Central Reserve Police Force or the Indian Railways. There might be some questions on the parity of work or the value of the work being rendered. When we are talking of a cleaner, can we
Let's
say
still
that
wait
there may
about
be-
your lordship till this time. But the order of the court should not prejudice anybody. That includes government also.
Yes,
We hope.
definitely.
That is my submission before your lordship. I cannot comment further.
Any reply?
You want to?
March of one.
Any more matters after this? You're ready, you're ready for hearing. Item 13. Item 10, okay. Heard Learned Counsel for the petitioner, Mr. M.T. Longcha. Also heard Mr. Moa Imchen, Learned Senior Government Advocate for the state respondents. Hearing is concluded, judgment reserved. And yes, how much time? Judgment reserved. Mr. PP,
March of one.
We're hearing item number 13.
No, I think we stand for the matter.
your PP, NIA.
Yes, sir.
Not PP, NIA, Mr. Such and such, just give your name, please, for 3 weeks time. Learned counsel for the respondent. There's no objections, list after 3 weeks.
For unlisted motion, item number 16.
May it please your lordships. Lordships, in this case, I'm challenging my detention order, which has been confirmed. Before I go into the details of this case, lordships, if I can point out to one document and one aspect of this case, and if your lordships are satisfied, orders may be passed. In this case, I was initially arrested on 23rd of February 2025, your lordships, and thereafter I was released on bail by the special court because my arrest was found to be in violation of Vihan Kumar's case. In that, need I inform your lordships about the ratio in that case, or lordships are aware? So on 27th of May, I was released on bail. When the situation was thus, my release order and the fact that I've been enlarged on bail was not informed by the sponsoring authority to the detaining authority. This aspect was withheld, and my detention order was passed on 5/6/2025. In the detention order, if we look at the grounds of detention order, which can be found at page 80. Lordships, may I take you to, may I read out para 3 of the detention order, page 88, annexure 16, that you are presently under judicial custody. On the basis of materials placed before me, I'm satisfied to so and so. So this fact, you are under judicial custody, this is totally false. Why? Because my bail order I have enclosed through an additional affidavit in this petition. After I filed this with petition.
Is it there in the amended petition?
No, it's there in the additional affidavit. On the day of motion, I move for a prayer to file an additional affidavit and place this bail order before this additional affidavit. Yeah,
And you were released on bail.
yes, on the 27th, before the special court.
You were released.
Yes, Your Worship. So this aspect was not disclosed to the detaining authority, and even the detaining authority failed to exercise. Lordships are aware of the cases in Guizhou, Penang, Jaung, Manipur, and even Dharmendra Chalawat. Those tests, double test awareness that the accused is in custody, eminence of likelihood of release, and foreseeability that he would likely continue with his prejudicial activity. All these aspects are to be taken into consideration by the detaining authority. But this aspect has, in fact, I received an affidavit filed by the state this morning. Even in the affidavit that I received this morning, the detaining authority demonstrate mechanical non-application of mind and mechanical way in how the detention order was passed. So based on this fact alone, if your lordships are satisfied, I did not even go into my other grounds. My other grounds are with regard to language, Murtuza Hussain and Hari Krishnan Singh, that I'm predominantly a Hindi Assamese speaker, and nothing material in the language that I understood were placed to me. That is also one of my grounds. The other grounds are I do not have any past.
Then how was the detention order served on you?
I was called to the police station after I was released, I was called to the police station. So according to my bail conditions, I'm supposed to comply with that. I went to the police station and then they took me under the custody for preventive detention. In fact, this bail order, Your Lordship's one very important aspect. This bail order has not been challenged by the state. No application for cancellation or bail. In fact, if this bail was granted on technical grounds, the state has steps to correct those technical issues, and rears may also. There are other modes they could have resorted to. But from the very beginning, they seemed adamant to put me under preventive detention. In fact,
What about union?
Union was I forgot to inform the union.
And state has filed counter today.
I felt yesterday with the chamber. However, Your Lordship, even the detention authority, because all the affidavit is being filed from the government level, from the detaining, so this record is not with us, Your Lordship, the bail petition regarding this. So we have not made any mention on this, Your Lordship.
And what about the file? The consular.
Everything is weak. At the time of passing of this detention order, the
authority, they were unaware of this failed petition.
That's what,
Yeah,
this
that's
is
right.
withheld or
That is
suppressed.
the point.
Yeah.
That is the point.
And like I said, Your Lordship, that awareness that he's in custody, the
Application of mine.
Yes,
Application of
yes.
mine.
On this alone, even if the union were there, they would have to file affidavit, but this situation, factual aspect cannot be improved by way of affidavit. That is what I believe, Your Lordships.
But it is proper that order is passed in the presence of.
Yes, Your Lordships. So Your Lordship may keep it part.
We cannot be part heard because this bench will not be there. It's next week we can put it on 15th.
Your Lordship, I have difficulty, Your Lordship, personal difficulty on that. That's why I also make an effort that.
No,
the matter
there are other
gets
government
mentioned.
advocates, so many of them are there.
Yes.
Anybody can appear.
That can do, Your
Yes.
Lordship, but after if there is filed, sometimes it becomes difficult for others to appear.
No, 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 it's a government panel, anybody. can-
Yes.
Your Lordship, if it's convenient on the next date, otherwise I will try to
Put it
make
on
an
the
endeavor.
15th, okay?
Oh, all
We'll
right.
make an endeavor to dispose of on the 15th. The Learned Counsel for the petitioner, Mr. Kohima, as well as Ms. Livika, government advocates. The Learned Counsel for the Learned CGC is absent. So the state respondents have also filed their affidavit in opposition. This is the matter on 15th then for admission hearing.
Yes, yes.
You inform the, of course, it will be there in the post list.
I'm obliged to you also.
It's not there.